Hello, hello, hello. Good morning, good afternoon, good evening, depending on your time zone. Welcome to my channel. My name is Ogbanje Joseph. Please subscribe to this channel, share, like, as well as drop a comment on the comment section. So, our lecture today is titled UN Pacific Settlement of Disputes. UN Pacific Settlement of Disputes. Now, in the aftermath of the Second World War and the Holocaust, the founders of the United Nations focused on reorienting international affairs away from aggression and unilateralism, to towards cooperation and multilateralism. Article 1 of the UN Charter concisely states that the organization, concisely states the organization's principal objective, which is to maintain international peace and security, and the ways in which the goal is to be attained collectively, peacefully, and preventively. At the dawn of the 21st century, the peaceful settlement of disputes is widely considered essential not only in the interest of avoiding deadly armed conflict, but also to counter the rise of extremism ideologies and ethno nationalism and a host of reasons. As a means of safeguarding international peace and security, Article 1 identifies two complementary aims. That is, to take effective collective measures, for prevention and removal of threats to peace and for the suppression of acts of aggression, on breaches of peace and to bring about, by peaceful means and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations which might lead to breach of peace. Thus, both preventing conflict and resolving disputes through peaceful means can be viewed as twin pillars in the foundations of the World Organization. Now, let us look at the measures, for peaceful settlement of disputes as prescribed by the United Nations. What are the measures for peaceful settlement of disputes as prescribed by the United Nations? Now, the measures are as follows. Number one, negotiation. Now, negotiation results in compromise between the parties in dispute. Okay, that is actually number one. Number one is negotiation, and of course, it results in compromise. Negotiation can be defined as the bargaining process existing between conflicting parties for the purpose of actually reaching a compromise, and find lasting solution to the problem. Okay, that's number one. Number two, fact finding. Now, this is actually a process whereby two parties actually find or initiate a commission of inquiry to establish infractions and suggest ways of settlement of the disputes. That's number two. Number three, mediation. Mediation refers to the offer by a third party of his good offices, to the parties in dispute for the purpose of actually finding peace, peaceful solution to the conflict. Okay, now it is done in the interest of seeking a resolution and preventing an escalation of conflict. So under this, there is a third party that actually weighs into the matter. Now, the parties involved in the conflict must actually allow for the third party to really come into the picture, because it has to be through the consent of the parties in conflict for the third party to actually mediate. Now, the decision of the mediator, of the mediation is not actually binding. But of course, the parties in conflict, they are under moral obligation to respect the decisions of the mediation. Okay, that's number two. Number three, conciliation. Now, conciliation is also a mechanism that combines fact finding and mediation. Now, it does not only engage the party to set out clearly the facts, but also to act as a mediator to propose solutions, that are mutually acceptable by the disputing parties. So that is actually conciliation. The next one, that's number four, is arbitration. Arbitration, necessitates the settlements of disputes in accordance with existing international legal standards. So decision under this decision is binding because it is according to the international legal standards. Okay, so that is actually for arbitration. Number five, international tribunals. Okay, this refers to International Court of Justice and other courts with international jurisdiction. Article 60 of the statutes, says their decisions are definitive and cannot be appealed. Okay, so number six is regional agencies or arrangements. Now, Article 33 of the United Nations leaves scope for referral of a dispute to regional agencies or arrangements like ECOWAS, EU, OSCE, etc. Okay, then number seven is, let us look at other peaceful measures. Now, according to Article 33, other peaceful measures are consultation, conferences, and political or non-judicial organs. Okay, now who are the actors in pacific settlement? Let us look at the actors in pacific settlements. Now, number one is parties to a conflict. Now, you cannot actually have actors in pacific settlement if you do not have the parties in the conflict. So the parties to a conflict must sit in a round table, on a dialogue table, to actually find, to find lasting peace, to the problem. So that is actually number one. Number two, Security Council. It is Security Council is an organ of the United Nations that is put in place to actually broker peace, okay, between parties in conflict. Now, when dialogue has failed, okay, of course, the Security Council can also use, uh, uh, can also use armed means to actually, ensure that there is peace between the warring parties. The next one is General Assembly of the United Nations. Now, the General Assembly of the United Nations is also an actor in pacific settlement of global disputes. Now, the United Nations General Assembly can meet, and then the resolution passed from that place can also be applied to the conflict. Then another actor, which is number four actor, is Secretary General. Now, the Secretary General is the first civil service in the world. Okay, he's the highest civil servant in the world, and he can use his good offices, to actually wade into a particular conflict situation. Number five, or number six, as case me, or number five is the Secretary General Special Envoys, Special Representatives, and Mediation Support Unit. Okay, this arm or this institution or this, you Secretary General's Special Envoy, Special Representative, Mediation Support Unit can actually be sent to, be sent to actually ensure that there is peace between warring parties. Okay, and then the last but not the least institution or actor in Pacific settlement is the International Court of Justice, the ICJ. ICJ is an institution put in place to ensure that parties in conflict, when they approach the ICJ, the decision of the ICJ actually is binding on all conflicting parties. Thank you very much.